Good evening. Tonight's topic is premises liability claims. People can suffer severe injury when on the property of others, whether in a hotel, restaurant, store, home, or apartment building. You need to know the rights and obligations of anyone involved in such an injury. Good evening, and welcome to Lawyers on the Line. I'm Stephanie Balmer, a partner with the Falsani Balmer, Peterson and Balmer Law Firm, and this evening's moderator. I'm pleased to welcome our finalists, Jim Balmer, a founding partner of the Falsani Balmer firm, and Steve Reyelts of the Reyelts Law Firm. We're ready for your questions. Call locally at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Well, let's start with some of the biggest news in our area today. I think probably most of our viewers have heard about the explosions and fires over in Superior at the refinery. Dad, let's start with you.
Okay.
You know, we're here talking about premises liability. What potential issues or legal liability do you see from a fire at this point?
Well, there's at least one non-refinery employee group that was on the premises at the time, as I understand it. So they might have, the employees involved might have claims against the refinery or whoever started the explosion for bodily injury. They were on the premises of the refinery at the time of the injury. Then the refinery workers themselves who are hurt have workers' compensation claims. The employees of the visiting contractor, which I think was Hunt Electric, also have workers' compensation claims. And if the refinery can show that some third party is responsible for the damage, they have a claim against the third party for the property damage, the cleanup costs, reimbursement for what they've had to pay out on account of their workers' injuries, and so on. And that brings up one point that I really want to emphasize to our viewers. Most people don't spend a lot of time thinking about the property damage coverage they have on their own homeowners policies, but the property damage from today's fire could easily go into the millions of dollars. Most of the time, those of us with homeowners policies don't have the need for millions of dollars of property damage coverage, but you do need to look at it with your agent. So make sure you're not getting just the minimum. Instead, make sure you get what you need.
Okay.
May I add to that?
Absolutely.
Thank you. So, of course, this all harkens back to June 30th, 1992, Toxic Tuesday. So, as far as we know at this point, there hasn't been a toxic element in the air. There's just all that black smoke.
Yeah.
But if there is, you know, if that were to happen, heaven forbid, in the Toxic Tuesday case, there was a class action set up for all of those people who might have been injured, you know, had personal injuries, had other conditions because of their exposure to that toxic cloud at that time. So that's another possibility here, that if that happens, there's always the possibility that there could be a class action set up. In the Toxic Tuesday case, there was in addition to the claims that were made immediately, there was also some concern that symptoms from exposure might show up over a period of time. So there was a fund set up with funds from Burlington Northern, a latent injury fund, to compensate people who might, you know, 5, 10, 15 years down the road wind up with symptoms that that were medically related to the exposure. So we don't know that that's the situation here yet. We hope it's not, but there's that. That's another group of potential claimants here as well.
Yeah, and then they in turn could also have some sort of property damage to their homes if there's some kind of damage that comes from the fumes and the smoke. So yeah, he makes a good point.
Well, and this is a good time to talk about any differences between the states. We have a caller wondering about the differences in the responsibilities of property owners in Wisconsin versus Minnesota. Steve, do you want to start?
Sure. So, yeah, in Minnesota, we all have the same duties if we are owners or possessors of property. So, whether it's Stephanie, your house, or Jim's house, or my house, and someone slips on the sidewalk, I mean, we still have the same duty to clear our sidewalk in a timely fashion and well, as does Menards or the Miller Hill Mall or other places. We've got that same duty.
I'm not sure there's such a duty in Minnesota any longer.
Well,
but keep
You
going.
let him finish, and
All right,
then you
okay.
can go.
You
Go ahead.
sound bitter about that.
He does, doesn't he?
Yeah.
Yeah.
So, but in Wisconsin has what's known as the Safe Place Statute. And that creates a heightened duty for landlords, employers, business owners, places where the public comes. So they have a duty, a higher standard than in Minnesota. They have to have a situation or a structure or a condition that's not perfect, but certainly as good as possible for that particular structure. Which is it's more than the duty of reasonable care than we have in Minnesota.
Yeah, I agree with Steve. I think it is easier for an injured person to be compensated as a result of an injury on business premises in Wisconsin than it is in Minnesota. I also think it's probably easier for somebody to be compensated if they're on a private home owner's property. But the Safe Place Statute doesn't apply, but there's a number of defenses not available to a homeowner in Wisconsin that are available to a Minnesota homeowner.
Like what?
Well, for one thing, as a practical matter, Minnesota believes that many Minnesota judges rule that if you get hurt on ice, it's your own fault regardless of how dangerous the premises people left the property. So if they've got a slippery sidewalk leading up to their business, a Minnesota judge is far more likely to dismiss the claim on the grounds that the injured person willingly assumed the risk of walking on the ice rather than blaming the business owner for allowing the icy condition to exist.
Steve, what's your take on that?
Yeah, I agree, and that's true. And it's, I mean, the Minnesota courts, our local courts here, on a number of cases recently, have found that there's no duty to warn, for instance, of an open and obvious danger. So, as Jim would say, if someone sees that there's an icy parking lot and chooses to encounter that, and they know that it's icy, then the courts have said, that's their own fault. The other thing with regard to snow and ice, this is true in Wisconsin too, but homeowners or business owners have a reasonable time to remove the condition. You don't have to be out there every half hour while the storm is raging. You can wait until the storm ends or a reasonable time after the storm ends to remove those snowy and icy conditions. So that's, to me, I mean, I usually represent defendants, and you and your dad usually represent plaintiffs, but to me those are good defenses in Minnesota, valid defenses, I mean.
And the standard you just mentioned about, what's reasonable as far as during a weather event versus afterwards, that's something that's come about through the courts and decisions based on various facts, right? I mean, it's not set in statute, is it?
No, it varies on the facts.
Okay. So we have a caller who wants to know about liability for people who were told to evacuate today because of the smoke and went to a hotel. Can they be reimbursed for hotel costs?
Well, I will start by telling you that I've heard that many of the hotels are letting these people who have no place else to go stay at no charge. So the local hotels have opened their doors to these people.
So it's worth asking anyhow.
Oh, yeah.
Okay.
Yeah.
What if they get told no?
They should pursue any out-of-pocket expenses. They should call the Husky refinery and tell them they expect a check in the mail. And the problem is that unless it's a really sizable amount of money, it's not worth hiring a lawyer. But they can go to conciliation court in Superior in Douglas County if they don't get compensated.
Right, and it may be that Husky or whoever ends up footing some of these costs pays it very willingly and sets up a hotline to handle these calls and whatnot.
I would be shocked if they did anything else, but if something goes wrong and they won't pay, then there is a remedy in conciliation court. But
Just to add to that,
Yep.
this is a story that came about today, but I had a call from my longtime secretary, office manager, and person who controls my life at the office. So the two of you know very well.
Yeah.
She and her family live in Superior within the evacuation area. They found a hotel, checked into a hotel, and the front desk clerk reminded them to keep their receipt and keep track of all their expenses. So that's good practical advice from the front desk clerk at the
That
hotel.
is very good advice.
Yeah.
And that applies to any type of case that we'd be talking about this evening, doesn't it?
oh yeah, absolutely. Keep
Okay.
track of your expenses.
A caller was told by her insurance agent that it is worse to have a no trespassing sign than no sign at all. Why would that be? What is the better approach? Is a person liable for injuries sustained on property if a sign is posted? So let's start with you, Dad, briefly.
Okay. I don't know what the insurance agent was thinking of. I think that if you don't want people on your property, your legal position is improved by saying so. And just saying no trespassing, private property.
So you think it's a good idea if
Yeah,
that's what you
put the
want to do?
signs up.
Steve, what do you think?
Yeah, I think so too. I mean, in Minnesota, for instance, there's a lesser duty owed to trespassers on property than there is to other people who come onto the property. You still are liable if you have a severe hazard, or, for instance, if it's children who come on, they come onto the property. There's an old doctrine called the attractive nuisance doctrine. So if you have an apple tree and that kids are coming into that, and you've got a big pit in front of the apple tree,
Full of spikes.
yeah, football. Right. You could be liable for that. Maybe what that agent was thinking of is this, though. I mean, in Minnesota, for instance, we have a recreational use statute, and where people can allow others to come onto their property for hunting, for instance, or for snowmobile trails sometimes go through private property, and the state, to encourage that, gives immunity to those people from injuries or damages on that property to people who are using it. So, maybe if you maybe the agent's idea is if you put a trespassing sign on that, you're saying, well, this isn't part of the recreational immunity statute, so maybe you might be hurting yourself there. Otherwise, I can't think of any other reason that you'd have a greater chance of liability if you don't have a no trespassing sign up.
And the other thing is that if you have the no trespassing signs up, you're less likely to have people intruding, which, regardless of legal liability, you don't want. You want your privacy, and you want, if you own the land, most people usually like to use it as they see fit. It's more difficult to do if people are coming and going as they please.
Okay. We have a caller who was walking on a sidewalk. A car pulled out of a parking ramp, blocking the sidewalk, causing the individual to go behind the car. The individual then got hit on the head with the stop arm of the parking ramp gate, presumably. Who is responsible for the medical bills?
Well, I could work with that.
Sure.
I think that a little bit of it is maybe the automobile, but the majority of it is the parking ramp. I need to know more to set it up, but it sounds to me as though the parking ramp has an arrangement that leads to this kind of problem. And the parking ramp either knows or should know that this can happen. And there are steps they can take to avoid that. A number of things they can do to prevent that.
Okay.
The parking ramp arm coming down after somebody's exited, I'm not sure why they need that. That's somewhat unusual.
Well, to keep cars from coming in and stealing parking.
Well, yeah, but if there's a car blocking the exit, well, in any event, this isn't, I'm not an architect, but there's ways to do this so that doesn't happen. That's a somewhat unusual accident, and I think the parking ramp operator is legally responsible for the medical bills. They might be able to get a little money from the auto carrier for the car, but
Okay.
the vast majority of the responsibility is for the parking ramp.
See, this is the difference between plaintiffs' lawyers and defense lawyers.
Just this difference?
So you have someone who's on a sidewalk, a car is stopped on the sidewalk. Instead of waiting for the car to pull out, that person chooses to walk behind the car, off the sidewalk, and in the vicinity of a stop arm going down. To me, the lion's share of the fault there is with the plaintiff who made that choice to do that.
We disagree.
So this sounds like some of your guys' cases. Yeah. All right, here's a caller who wants to know what can be done about a neighbor who is using overly scented dryer sheets that emit a strong scent through the dryer vent. The other neighbor is allergic and is bothered by the scent. So I remember studying some of these cases in law school about situations where a strong odor, or even, we talked about smoke with particles, would be caused to go into another person's property. Steve,
Yeah.
do you want to start with that? You have anything to say about this question?
Well, part of it is, first of all, notice. I mean, does the homeowner who has that toxic, allegedly, or not toxic necessarily, but something that creates a problem with someone who has a allergy or a heightened sensibility, are they on notice that this problem exists? So then if you tell them, then if they persist, maybe you have a claim where they've been put on notice and they're not, abiding by your wishes. But it's not illegal. It's not outside of what a reasonable person would do, and that is to allow, scents to come out of their house. So, to me, I think it's a pretty tough claim for the neighbor who has this sensitivity.
Okay.
It's hard to believe we get along. I was jogging yesterday and I smelled dryer sheets going by a couple of houses on my route.
Was it my house?
No. You guys are real good about that sort of thing.
We're so far from the road.
Well, maybe that's
helps.
it. But in any event, it can be very obnoxious. But I think the real problem with the case is, how do you prove that you've been harmed? It's not enough, I don't think, just to say, I don't like it, it's unpleasant. Although I agree it is. But if you have an actual allergy, I know people who are allergic to those perfumes.
Yeah, and that's
Now you've got a claim.
Okay.
And I think it's worth pursuing. And I think a judge would allow relief to somebody who's got an allergy against a stubborn neighbor who refuses to do something about it.
Okay. Here's a caller who wants to know about liability for a tenant, landlord. So maybe the question is, who's responsible between a tenant or a landlord for cleaning up dog waste on rental property? Is it a similar analysis to keeping sidewalks cleared? Dad, you want to start with that one?
Sure. The first thing to look at is the lease, the terms of the lease. They can be oral, although it's better to have them in writing. And if the yard is considered a common area, then the question is whether the tenant, I assume it's the tenant whose dog is fouling the lawn.
It's unclear.
It's unclear. It could be the landlord.
Right.
If the lease is silent, although most of them, even the pre-printed leases, say something about the tenant shall keep the common areas free and clear of all whatever. And so if that's in the lease, I think that the tenant, if it's the tenant's animal, tenant's got to keep it clear.
What if it's not the tenant's animal?
If it's the landlord's, then the landlord is depriving the tenant, and we have a landlord to our right here, of the fair use of the property, and I think the landlord is violating the terms of the lease.
Steve, what if it's neither of their animal? What if it's just random passersby? Who bears that responsibility?
Oh, gosh.
Well, I don't think that the landlord is responsible for that. Unless the landlord is allowing someone to come by their place. I mean, it's we have an ordinance in Duluth. Animal owners are required to pick up after their animals, and it's the responsibility of the owner of the animal. Unless there's some other factors where the landlord has somehow permitted that situation to continue and could have had the opportunity or the means to prevent that.
Okay. We have a caller who wants to know how are elderly people supposed to keep up with cleaning sidewalks when they can't even get outside to shovel due to age and or medical conditions. Dad, does someone's personal situation, whether it's medical, age, or both, affect their duty to guests and passersby?
Well, technically, a homeowner in Duluth has a duty certainly to keep his or her own sidewalks clear, and that would extend to the sidewalks going in front of their house, even though those are public sidewalks. There's a city ordinance that requires all homeowners or property owners to keep the abutting sidewalks clear.
But what if you physically can't do it?
I don't believe that there's any exception in the ordinance or the law for that. The homeowner has a legal obligation to do something about it. Two things. First, I've never seen the ordinance on the public sidewalks enforced against a homeowner. I know there was talk of it, but it never actually happened. Secondly, I suspect Mr. Reyelts might have a different view. And so I think you ought to ask him to weigh in too.
All right, Steve, any thoughts?
Well, no, I think there's a duty and there's no way around the duty. The duty is the duty, no matter what your circumstance. You can hire someone, you can hire the neighbor kid to shovel off, or you can hire some, agency to do that. But, it's, you still have the duty. And I totally agree with what Jim is saying about the public sidewalks. For instance, on Park Point or other places, the plow goes by. Those poor people who actually shovel the sidewalk, the plow goes by, that evening, and there it is, and then it gets icy, and it's impossible to remove. I mean, so it is very, very tough for homeowners in Duluth to keep a public sidewalk.
And
there.
I know someone who runs in the middle of the street on Park Point, because theoretically it's maintained better than some of the sidewalks.
Oh, it absolutely is. Yeah. So I mean, maybe I'm the guy that runs down the street.
Yeah,
but
could be.
The other thing is, I had a case once where I asked the judge to instruct the jury that the failure to keep the public sidewalk shoveled was negligence on the part of the homeowner, and the judge grudgingly did it. Jury ignored it. Jury didn't care.
I think that's another show. That's our last show of the season.
Oh yeah,
The
okay,
juries do
right.
with their
But my
instructions.
point is that I wouldn't get too tense about this.
Okay. So what you're saying is that if and when a case like this proceeds all the way to a trial of your peers, that those factors might be considered.
Yeah.
Okay.
Yeah.
All right. We have a caller. A disabled female with 40 acres cannot get out to put up no trespassing. So a similar question. Is she protected because she is disabled? So.
Again, I don't think it makes any difference whether she's disabled or not.
Yeah.
On the one hand, on the other hand, you don't need to have no trespassing signs for there to be trespassers. In other words, if you have private property and you haven't somehow granted permission or dedicated that property for recreational use, it's trespassing. Whether there's a sign or not. Okay. The reason you have a sign is that it's a better argument that you've put others on notice that they're not to trespass on your property. But even if you don't have a sign and someone's on your property without permission, they're trespassing.
Yeah, the sign doesn't magically change somebody from someone who has a free right to come and go as they please into somebody who's not allowed to. Steve's right. I mean, I certainly agree with him. You're a trespasser whether the sign's up or not. It's just that if the sign's up, people are less likely to come onto your land.
Something we haven't heard a lot about are dog bites.
Oh,
and
yeah.
I personally had heard that liability can be affected as far as whether you put up a sign saying warning dangerous dog versus otherwise.
Okay, so there's somebody who lives near Steve who has a warning vicious dog sign up. And, if I were to go onto that property despite the sign and get bit, the strong argument can be made that I was in a place where I could not lawfully be. And defense to a dog bite case is if the victim was someplace where they were not allowed to lawfully be.
What if they were invited there? And
Well,
there was a sign
then the
saying
sign
vicious
doesn't make
dog?
any difference.
Does it make it easier to prove that the defendant knew their dog was dangerous and still didn't take reasonable steps?
I suppose that's right, except that Minnesota and Wisconsin both have first bite statutes, which means that you don't have to prove that the dog owner was aware of the dog's vicious propensities in order to recover. It's enough if you're bit by the dog.
The one defense to that is provocation.
Oh, yeah.
Yeah. So otherwise, the dog owner is pretty much liable for any bite or attack that the dog perpetrates, except provocation. So if Jim is going by that, jogging down the middle of the street by that place where there's the dangerous dog sign, and he goes up to the dog and starts taunting it or poking a stick at it or something, then that would be a defense.
He wouldn't have much of a case.
No, I don't know.
The other interesting thing about the dog, and it's a dog attack statute. So it usually involves a bite, but it can involve a dog just knocking someone over, or not even a dog just approaching someone and
scaring
them. I had a case like that. It was a nice little rural ma and pa hardware store where they had a dog in the back, and a customer came into the front, and then they were going to look at some samples. They went to the back, and the dog didn't attack, just came up to the person. She went
Caused
flying.
him to fall.
Yep.
Wow, I didn't realize that. That's interesting. Well, with that, that's all the time we have. Please join us next week when we answer your questions about family law. I want to thank our panelists this evening and thank you for watching. I'm Stephanie Balmer. Good night.